In this case, the report indicates he was a .377 when he punched an officer in the face. We then get the report that tests positive for alcohol. He says it was mouthwash. That sounds to me like excuses to allow him to drink.
Frankly, that's what alcoholics do, particularly when they're caught. You just keep making excuses.
Good morning, Your Honor. Ashley Hannibal requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Stephanie Cannon.
Permission to practice is granted.
All right. On behalf of Mr. Bunch. Your name?
Paul. All right. You're requesting, or not?
Yes, Your Honor.
All right. I will adjourn the matter. I'll adjourn it to the 20th. However, we have a bond violation court. Are you aware?
I was not, no.
Well, if we July 20th, a positive alcohol test, and then a series where he did not retest.
Sorry, Your Honor, Stephanie Cannon on behalf of Mr. Bunch. Your Honor, I was unaware of those allegations. My client, of course.
July 20th, 2026 at 6 a.m., Mr. Bunch submitted a positive test with a blood alcohol content of 0.035. On that same day, at 6:23 a.m., he submitted another positive test, 0.034. And 6:47 a.m., blood alcohol content of 0.032. And at 7:14, that same day, blood alcohol content of 0.024. On that same day, as pursuant to what the program that he's in the testing, he was to submit to scheduled retest. He failed to do so on that same date at 7:29, 7:59, and 8:29. Did not retest.
Have you been testing since then?
Yeah, it didn't tell me to retest.
Thank you, Your Honor. My client is aware of the allegations against him. Are we arraigning him on this, Your Honor, at the moment, or just letting me know what's happening?
Well, he happened to show up before there was a warrant that was signed.
Okay.
So it was going to be a no bond warrant, but.
Thank you. Your Honor, I've spoken to my client regarding, he's heard that, he's been talking to me. It's my understanding that since then he has not been testing positive. He is going to AA, he has a sponsor. He's not going to tell the court that he has not or had not struggled with his sobriety up until then. But as a result, he has taken every step he can possibly take to remain sober. He has his AA paperwork with him today.
Is he admitting to these or not?
The 721.
Because here's what he told Community Corrections. They contacted him on that same day. He denied consuming alcohol.
Your Honor,
and then stated it must have been his mouthwash.
Your Honor,
I haven't heard that one in a minute.
Yeah.
Because that takes a pretty powerful mouthwash to last that long.
This testing sequence creates a serious credibility problem for the defendant. A single low reading might invite questions about contamination, but the court has 4 positive results, from 0.035 down to 0.024, spread across more than an hour. That declining pattern may appear more consistent with alcohol leaving his system than a brief mouthwash exposure. Just as damaging, he missed 3 scheduled retests. Those missed tests prevented Community Corrections from collecting the very evidence that might have supported an innocent explanation. Notice the defense attorney's strategy. She first determines whether this is a formal arraignment on the violation, then pivots toward mitigation, AA attendance, a sponsor, counseling, and subsequent negative tests. That is sensible because disputing documented results without supporting evidence could further damage credibility. but the defendant's earlier denial remains a major obstacle. Bond supervision depends heavily on honesty and compliance, not merely avoiding a new criminal charge. Do you think the mouthwash explanation could survive this timeline? And if the alcohol was consumed accidentally, why were the required retests missed? Judge Simpson is now evaluating more than alcohol use. He is deciding whether this defendant can be trusted outside custody.
In talking to my client, that is not what he told me when he talked to me about it. He was very truthful.
Okay.
And forthcoming, and he's not going to tell the court anything different than what he told me regarding that particular incident, that situation. As a direct result of that, though, he did take every step possible that he could take to make a sobriety. He started going to AA. He started working with a counselor. He's been doing everything he could as it relates to that, Your Honor. So he is. Are you going to admit to that drinking incident? You need to be truthful that you drink.
Levi did.
Yes, Your Honor. He is admitting that. He's admitting
That what?
that he had a mixed drink on that day.
Why didn't you just tell Community Corrections Center?
Your Honor, I believe my client wanted the opportunity to just go and take care of it. He started doing everything he could. Like I told you, he has proof of AA. He has proof of him taking care of his sobriety. I think in that moment, he just, he didn't want to have to go back to jail. He wanted to put steps in place so that he perhaps didn't have to go to jail as a result of that violation.
I didn't have any intention of drinking. I didn't realize there was alcohol in the house. I woke up in the middle of the night. I drank something. You couldn't undrink it.
You realize there was alcohol where?
In my house. Anyway.
Your Honor, he's just, when he spoke to me about it, he said he made a very bad mistake. He understood his mistake. He's been trying to fix that day. So he is going to admit that he did have a drink that day.
What's he been doing since the 20th to try to resolve it?
Yes, his AA paperwork. Yes,
Wasn't he at that before?
were you attending AA before?
Yes.
He has his AA paperwork.
So what's he done different given this event?
Oh yeah. He's been working with his sobriety coach intently, Your Honor. He tells me that since that incident, he has not had anything to drink. It indicated that it really was almost reflex because he has been drinking for that long. He admits that it was almost like just a reflex, and once it happened, he knew he couldn't fix it, so he called his sponsor. He's been working as best he can to maintain his sobriety since that incident.
Mr. Cook.
Your Honor, people are going to be asking for remand with potential consideration of release to treatment down the line, but I have some suggestions for this defendant, and that it seems to me he has an alcohol problem, and that problem is winning. And I don't think that if he's released, he can on his own get the treatment needed to help him to work on this. My concerns arise both from the history of this defendant, the underlying facts or allegations of this case, as well as some statements that have been made. Specifically as it relates to the defendant's prior history, he has a prior operating while intoxicated second, as well as allowing an intoxicated individual to drive. In this case, the report indicates he was a .377 when he punched an officer in the face. And then I also have concerns because looking at the notes from arraignment, it indicates our office had initially requested a scram tether. The defendant at that time indicated that wouldn't work for him because he worked with, I think it was cleaning, alcohol for cleaning. So a scram would be appropriate. We then get the report that tests positive for alcohol. He says it was mouthwash. Now we're hearing today that he thinks it was something he didn't know had alcohol in it. That sounds to me like excuses to allow him to drink. And I think that I don't think he wants to be drinking, but I don't think he can be trusted on his own not to drink. So I believe remand is necessary for his own betterment, in this case, as well as for public safety and compliance.
This is about the best we're going to do at this point. Let's get you treatment.
Get my lost bench.
The prosecution has now connected the violation to a broader public safety argument. This is not being presented as one isolated drink. The court is hearing about a prior second offense operating while intoxicated conviction, an allegation that the defendant had a 377 alcohol level when he punched an officer, resistance to scram monitoring, the mouthwash denial, and now a different explanation involving an unidentified drink at home. Each detail reinforces the same concern: inadequate control combined with shifting explanations. The defense makes an important distinction. The newest incident did not involve driving, but bond decisions are preventative. Judge Simpson does not have to wait for another impaired driving event before responding to a demonstrated supervision failure. The real question is whether less restrictive conditions can reasonably manage the risk. Treatment therefore becomes both a rehabilitative option and a courtroom compromise. Defense counsel is no longer arguing that ordinary release is working. She is asking for release directly into inpatient treatment. That protects her client from remaining jailed, while acknowledging that self-managed sobriety may be insufficient. Did you notice how the defense's position changed from emphasizing AA paperwork to effectively conceding the need for structured care? The next decision will turn on whether treatment can provide enough control to satisfy the judge's safety concerns.
Your Honor, if the court is inclined to remand him today, I would ask that he be allowed to be released to treatment as well. My client is not arguing that he is not struggling. He wasn't drinking at the time of this. I'm sorry, he wasn't driving at the time of his recent incident. The one that brings him before the court to let the court know that he was at a restaurant trying to get something to eat, and the police were called. But he is struggling. He's not denying it. He's not going to deny it to you. He's not going to deny it to anyone. It's an addiction that is socially acceptable at times, and he is struggling, Your Honor.
Turn this to the 20th. I will potentially allow release to inpatient treatment if you
I'll get you in order, Your
order. That would have to be with the just Tyler. So I'm adjourning it to the 20th. I'll sign that order. And at this point, I don't think you know what you really want to say, because Mr. Cook is right. Everything that you're saying is making excuses. And frankly, that's what alcoholics do, particularly when they're caught. You just keep making excuses. So you have to make a determination as to really whether or not you want to deal with this or not. But you'll have time to think about it. Defendant's bond is revoked. Andrew.
Thank you, Your Honor. Let me get this back.
Court does call the case of Ibrahim Abdullah Al-Bassar.
Honor, Kadmadadush, on behalf of Mr. Abdullah, Allah, can you please say your name for the record?
Ibrahim Abdullah Al-Bassar. I've called this case early. It was down at our access point. My understanding is, first of all, tested positive. We're informed from community corrections. We haven't issued the bench warrant yet for fentanyl. Was that yesterday?
Yes.
That was yesterday. Our understanding also is that you've been using this morning.
No, not this one. I just had some stuff in my pockets from using. But that was the last thing. It just in my system.
Your Honor, did
I don't.
They hit their assault on from the top.
Pardon?
I don't know that I didn't at on.
For an adjournment so that get the bond.
Given the information from yesterday's morning, his bond. In this case, counsel approach. Right, record should reflect we've had a bench conference in this case. What I will do is I will grant the adjournment based on the information the court has, subject to a motion by the defense at this time. Also, in viewing the defendant's case, I'll adjourn his probable cause for 2 weeks to the 20th, 2026 at 9. At this point, the defendant's bond is revoked.
Judge Simpson ultimately revokes Mr. Bunch's bond, but he also leaves a controlled path toward inpatient treatment. That ruling reflects two separate judicial goals: protecting the public and addressing the addiction driving the risk. The violation was supported by 4 positive alcohol readings and 3 missed retests. More importantly, the defendant's credibility deteriorated as the explanation moved from mouthwash to an accidentally consumed mixed drink. His later admission was better than continuing the denial, but it came only after the testing record was presented. The defense did achieve something meaningful. By acknowledging the addiction and requesting release directly into treatment, counsel gave the court an alternative to simple incarceration. Still, AA paperwork and a sponsor could not erase the supervision violation, the prior alcohol-related history, or the court's concern that he could not safely manage sobriety on his own. The second hearing shows how quickly similar bond issues can develop. Mr. Abdullah was called early after community corrections reported a fentanyl-positive test, before a bench warrant had been issued. When questioned about possible recent use, his response about substances remaining in his pockets from years of use was unclear and did little to resolve the court's immediate concern. After conferring with counsel, Judge Simpson adjourned the probable cause proceedings to the 20th while addressing bond based on the information then available. The broader lesson is straightforward. On supervised release, testing compliance and truthful explanations are evidence of reliability. Missing retests or offering inconsistent accounts can become as consequential as the positive result itself. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.